Due to some personal difficulty, if I may pray for an adjournment, item 9 and 10, husband and wife.
9 and 10. Okay. Mr. P. Borodwas 9, Land Council for the petitioner. On the ground of his personal difficulty has prayed for an adjournment of the case. The Land Council for the state respondents are present and have no objection to the said prayer for adjournment. First of as prayed for, release the case after 2 weeks.
2nd of May, my lord. Since motion item, that's why.
2 weeks. Same item 10.
Published.
May I please your lordship, I beg to mention one WBC. After Bihu vacation any May, any date may be given.
After view vacation. In what column?
Hearing
Okay. Hearing, you have to
Hearing.
make an
due
application.
to paucity of time, the matter has not been reached. Earlier date.
No, you have to make an application before the registry
I have
regarding
been-
hearing item.
I have-
Okay, it will be,
But till the matter has.
it will be listed then.
May I please lordship, item number 19,
19.
due to personal difficulties of my senior, matter may be adjourned for today.
Mr.
M. Dotto,
M,
M. Dotto,
your name?
L. Deka.
L. Deka. Learned Counsel appearing for Mr. M. Dotto. Learned Counsel for the petition has sought for an adjournment on the ground of personal difficulty on the part of Mr. M. Dotto. So it is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. As prayed for, is the case after 2 weeks, on 2 weeks by the office.
May I please your lordship, I beg to mention item number 8. Lordship,
8.
the matter may be listed after Bihu vacation, lordship. Today my
Okay.
seat.
Miss
D. Bora.
D.
on
Bora,
behalf of-
Learned Counsel for the petitioner has appearing for the petitioner has made a prayer for adjournment after the ensuing Bihu vacation in April 2025. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. As prayed for, release the case immediately after the ensuing Bihu vacation in April 2025.
Daily list for motion, items 1 and 2.
1 and 2, again.
Item 2 is different lordship.
Item 2 is different, my lord.
Item 2 is different.
Yes, my lord.
That may be taken.
On the prayer, release these matters. Why it has been listed together? Why it is listed together?
I don't know, my lord. That's because my last,
Is there any order?
no, my lord.
Second or so? Nine. I go to 9. I go to order 9. Okay, so. Yes, Mr. Soman, there is no such order
Yes, lord.
to list the cases together.
Yes, lord. That may be taken.
Yes, about item number 1.
Item number 1, my lord. It's an expert order, my lord. Expertise has been, my lord, dated, my lord. 27/4/2028, my lord. By
Mhm.
which, my lord, one Zaimona Khatun, wife of Mohon Ali, has been declared to be a foreigner, my lord. But here,
Joymona Khatun.
Zaimona Khatun, my lord. Here, my lord, the petitioner is Maimuna Khatun, wife of Mohor Ali. After 7 years of judgment, my lord, now the petitioner has been sought to be arrested, my lord. That judgment is sought to be implemented upon the petitioner, my lord. It's totally different person. My lord. But There is a similarity of name, my lord.
Hmm?
Address is same, my lord. Last time.
It is same husband name, same lordship.
Hmm?
Lordship, lordship will kindly see page 19. Here also Moimona Khatun's name is reflected lordship.
The inquiry, my lord, in inquiry, the petitioner's inquiry was said to have been conducted against the petitioner, my lord.
Moimona,
Maimona.
Moimona.
All these things are lordship matters of fiscal determination and lordship appropriate forum for this is concerned for an tribunal.
Yes. Inquiry to Maimona, yes.
Where this on the basis of report submitted by ERO 12/1998. Is this report, page 19?
Page 90, yes, my lord.
This is the report.
This is the report.
Page 22, what is this? Page 22?
Page 22, my lord, after inquiry, my lord, and the said letter has been submitted to the SP border, my lord.
No. Yes.
SP border for registering a case against on Joymona Khatun.
ERO's report.
Yes.
Hmm. Hmm.
In this case, police did not conduct the inquiry. Lordship. The voters.
Hmm?
The voters case lordship here is such type of cases lordship police did not conduct the inquiry lordship.
This FT opinion,
Yes.
page 29,
Page 29.
it refers to report of the ERO. Report on the basis of the report submitted by the ERO dated 12/1/1998 to the SP Borpeta, who on being satisfied with the report of the ERO about the doubtful nature of the nationality of the proceeding forwarded the reference for FT opinion. And this is, I think, page 22 is the ERO report.
Yes.
Para 5. ERO says having doubt about the citizenship.
Yes.
Then what happens?
What happens, my lord?
I don't know the procedure. That is
yes.
why I'm asking you.
Joymona has been
Then
declared.
lordship, it was forwarded to concern SP lordship. And then concerned SP forwarded this to concern foreigners tribunal for opinion lordship.
Then why ex parte? It a Mohan Joymona
Joymona.
Khatun.
Yes, my lord.
ERO report says Joymona Khatun, wife of Mohan Ali.
Mohan Ali. Yes, my lord.
So,
She has been declared to be a foreigner, my lord. By the expert order, my lord.
okay. And this
As-
petitioner is what?
Maimona Khatun.
Moimona Khatun,
Maimona Khatun,
wife of Mohor Ali.
Mohor Ali.
Yes, what to do in this type of cases?
Lordship, this is lordship. Page 19 lordship, here inquiries against Moimona Khatun lordship. And
Page?
Page 19.
And
19.
lordship, some maybe there is some spelling mistake lordship in place of J. In place
Zaimona.
of M lordship.
Hmm?
J is quoted lordship. So
It is.
lordship, all these things are matters of
Joymona and Moimona ধৰিব পৰা নাই না? Moimona
Maimona.
Moimona Khatun. Mohor Ali. Mohor Ali. This is page 19 is what?
Inquiry
It's
report.
a verification officer's report. lordship.
Verification officer report. After verification officer's report, what happens?
Lordship, it was submitted before the concerned ERO.
ERO.
Yes, Lord.
ERO
Yes.
says now
Yes, Lordship.
Joymona.
Jaimon.
Some
Verification officer says Moimona. ERO says Joymona. Verification officer says Mohor Ali. ERO says Mohan Ali.
Case was registered against Jaimona.
Joymona,
Yes.
Khatun, and Mohan Ali. Ah.
The procedure, what happens for procedures, my lord, what they are in debuter cases, these are called cases of debuter, my lord. The my lord, the initiation is from the ERO, my lord, electoral registration official. As per the my lord, direction of the my lord, ECI, Election Commission of India, in 1997, there was, as your lordship knows well, my lord.
I have
the-
forgotten everything.
My lord, the intensive revision was done. And while in intensive revision in 1997, a name has been found suddenly in a voter list. My lord, the ERO direct the LBO to verify whether the person's name can be continued in the voter list or not. And after the verification, if the my lord, LVO is not the my lord, officer from the election office, he is by some other else from some other office. My lord. He's an independent person, not from the election office. So,
Government official.
yes, he's a government office. He's not from the elections office. My lord. So he's an independent person. But he's directed to get a verification whether the person's name can be continued in the voter list, because his name is doubtfully appearing in the voter list in 1997. Now, LVO has to submit a my lord, a proper report so that the ERO can continue his voter name in the voter list. If the LBO report is not satisfactory to the ERO, he has no alternative but to send the matter to Foreigners Tribunal for a determination. That is the problem.
Now,
Now, my lord, the ERO has, my lord, this initiated the proceeding against this, my lord.
so this page 22
Yes.
is prior to LVO report or after LVO report?
After LP.
Page 23 is the, my lord. Yes.
Page 23.
Yes,
It is after
after LBO report.
after LVO report.
Yes,
Now, when LVO says Moimona,
Yes.
how can he say Joymona?
my lord, it will be Joymona. The proceeding will be against Joymona only because her name was suddenly appeared in the voter list in 1997, for which against Joymona, the order was met again to make a verification by the LVO.
LVO, to the LVO.
Yes. Now LVO's duty was to produce, my lord, to bring everything, all the records, whatever it may be, my lord, before the ERO to satisfy the ERO that yes, Joymona is there. So Joymona's name can be continued in the voter list. If LVO report is somehow defect, but nothing is found in the LVO report, the my lord, ERO has to send Joymona for my lord, determination.
Okay,
There is no alternative but to my lord, for
Okay.
the ERO.
okay.
That is the issue. My lord, and LVO report, it is collected by some other person, not from the ERO's office, my lord, it is by some independent person. He has to go to village, he has to verify everything, documents, person's name. If in that process, my lord, he or she, the proceeding gives us different name, it cannot be, my lord, say the ERO is wrong. She may give different name also, while verifying, my lord. This is the verification report by LVO. So we cannot, my lord, this report, my lord, page 19 report by the LVO, it is to be such a nature that my ERO has to satisfy this report. If he is not satisfied, he has to send a matter to Foreigners Tribunal.
Okay, let us take it as a Joymona. ERO. Then page 29 opinion.
Now, my lord, kindly see the page number 40, my lord.
No, we'll go to that.
Voter list of 1990.
No, we'll go to that.
Yes, my lord.
29 is the opinion.
Yes.
And opinion says notice was served by hanging in conspicuous point of the village club.
Yes, my lord.
Village club.
Yes.
as no trace or place of residence pertaining to proceeding was found at the village on record, as reported by the process server, accompanied with a certificate obtained from Gambura.
That is not as per that your lordship may take it, it is not as per procedure, because procedure, as per procedure, it has to be hanged. If the person is not found, it has to be hanged in the conspicuous part of the house where she or he last resided.
Hmm.
That is.
There is no trace, then
Then-
there is no trace, he says,
Yes.
process server.
If it is not traced out, my lord,
Now petitioner proceeding has appeared before this court.
no, it can be remanded on this ground, my lord. I'm not on that.
Okay.
I'm not. If-
Right.
Yes. On this point, it can be remanded.
Yes.
Notice was not properly served.
Hmm.
Itself, it can be remanded. If I guess it's-
এই record check করে নিন।
For order G5F. Yes.
C5 এর problem কোনটা ওটা? কোনটা?
1964.
Hmm?
1964 order. In this book, pilot, it is page one, 158.
158.
Yes. 160 is the proof. '59 is the Foreigners Tribunal Order 1964. Page 160, my lord, yes.
Now, conspicuous part of the house in which the proceeding ordinarily resides, that is not known.
Yes.
Last resided not known. Reportedly resided or personally work for gain or carries on business. And nothing is mentioned anywhere.
Yes. That's right.
Then there is no other option. What to do?
Then, my lord, the
Because LVO went to the local area.
Yes.
He could not found trace of Joymona. He found trace of Moymona. So it is also not established that Joymona last resided there in that area. So what is the substituted manner?
substitute manner, my lord,
What I am asking is that when LVO went,
Yes.
he found no trace of Joymona. He found trace of Moymona,
Yes.
wife of so and so. So the names are not matching. So Joymona's last residence is not known. Not known.
Yes.
Not known. ERO says it to the SP. SP sends it to the tribunal. And tribunal sends the notice to the address, which is the address of Moymona. So Joymona's address is not known. Apparently.
Apparently, that is.
Then what you say, 3F.
G5F.
What is the that hanging hanging of the notice in the say Gaon Panchayat office or anything like that?
There is no problem.
No, then how the substituted manner, he hanged it in the club, village club. Right, he says conspicuous point of the village club has no, it should be stress, I don't know what is the meaning, place of residence is found at the village.
We have to the investigate, my lord, the.
This
inquiry was-
foreigner order does not speak about any substituted manner.
This is the only.
Say office of the Gaon Panchayat or something like that, office of the BDO or something, or office of the deputy commissioner.
Yes.
Nothing. I have looked at this order after many years. So in such a situation, what? Let the regular bench sits and they decide. So in other cases,
Yes, yes.
better to have the matter decided well. But LVO report is not saying anything about Joy Mona.
Yes.
So, yes, there is existence of Joy Mona on art,
Yes.
but existence of Joy Mona in that village was not
In
there.
the voter list and house number, my lord, in the voter
House
list,
number,
there is
yes,
no-
where is that? Let us see now. The Joy Mona's voter
Yes.
list.
Uh,
Joy Mona's voter list.
But it is Moimuna's voter list, my lord.
Huh?
In the petitioner's voter list, my lord, 1997, my lord, as per my learned friend says, my lord. In the intensive voter list, my lord, 1997, my lord,
Joy Mona.
which is at page, my lord, vernacular copy, my lord, 41, my lord. Serial number 1016, my lord,
Joy Mona.
Moimuna.
But reference was not for Moyona.
Yes, my lord.
Where is your voter list?
Page 41, my lord.
Moyona.
Serial number 1016. 1016.
Mohor.
Yes, my lord.
If the process server had the process server gone with the notice of Moimona, he could have traced him, her.
Yes, my lord.
Now, if it is with Joymona, it is very difficult. A very initiation, Moimona Mohor Ali, Joymona. Now, where is Joymona? Joymona's name. If Mr. Payang's submission is correct, that Joymona's name appears doubtfully.
Yes, my lord.
Now, where is the trace of Joymona? It is not Moimona's burden.
Yes.
She is concerned with her name, Joymona.
Yes.
Now, ERO finds Joymona somewhere
Yes.
to be doubtful voter. No, right? Correct me if I am wrong.
Yes, my lord.
I am only saying from common knowledge, common course of event. ERO cannot write a name from his, picked up the name out of the blue and put it in the ERO report. Joymona Khatun Mohan Ali, house to house done during so and so.
Probably. my lord,
Zonia, electoral roll. Somewhere it is there perhaps in the electoral roll.
Maybe it is the same person, my lord.
Maybe he has written it wrongly,
Wrongly, my lord.
picked up wrongly
No.
Yes, my lord.
Moimona Khatun in the.
because of the handwriting of that person.
In the 1997 voter list, it is Moimona Khatun, wife of Mohar.
Where?
In my lord,
Page 41.
page 41.
Yes, 41.
ERO report, the LBO.
Yes, ERO report. Where is
Yes,
it? Original ERO report is available here. এইখিনি কাগজি madam এইখিনি কাগজি
In the year of page 23,
superintendent
Joymona Khatun,
Joy.
wife of Maharani,
SP says Joymona Khatun.
because it is forwarded as Joymona Maharani.
Joymona. SP says Joymona.
Husband name is same,
No, my
No,
Mahar.
Mohon,
Mohor.
Mohon.
Mohor. ERO says Joymona Khatun Mohor Ali
Maharani.
and Ghugubari village.
Till date, my lord, she is residing there. my lord.
But year of. The 1997 is total list is of Gugubari village.
Ah,
Moimona Khatun is Mohor.
ah. Then whole,
Only difference is Moimona become Joymona in the mother.
Ah. but it is done by
Year.
LBO. LBO says Joymona.
No, LBO says Moimona.
Huh?
LBO says Moimona.
Etu ki? Joymona.
Annexure B, it is by year of money.
See, Mr. LBO report, I have made necessary verification in respect of Srimati Joymona Khatun. My verification reveals the following particulars. Now there is overwriting.
Yes.
Find out.
Initially, it was Zaimonite.
Then
Subsequently, J is made M. J, M.
it is. Later on it is.
Hmm?
But in the.
So we have to, we have to go by ERO and SP.
Yes, my lord, this is Joymona Khatun. And in the event this, my lord, LBO report also, it is in the first line, as described, as desired by, I have made necessary verification in respect of
Joymona.
Srimati Joymona Khatun by making an on the spot visit. But she probably, my lord, she visited in the Moimona's house. Then later on, he has named
Yes. J is
Moimona
made
Khatun.
M.
Other particulars some same matter.
Huh?
Except-
But husband name is different.
Husband name is same.
No,
Mohor and Mohon.
Mohor and Mohon.
Mohon in the reference, sorry, opinion. Wife of Mohon Ali.
No, Yaro has said Mohor, my lord, but.
Hmm?
Yero Mohon.
Mohor.
Hmm?
Yaro also says Mohor. Probably it is, my lord, the,
To M.
well.
So,
My lord, may can see Yaro also. The, actually, that has been misconstrued by. It should be Mohor. Because it is not, oh, my lord, Mohar, Mohar.
Hmm.
So it has been misconstrued and
No.
wrongly written as Mohar. Otherwise, this is.
Moimona. He wrote Joymona. Then again, M was overwritten
Yes.
over J.
No, that is correct, madam. That is the.
This
in fact,
LVO.
LVO in first line also he has.
Joymona. Then he, in the name,
In the name.
he
has
initially read Joymona.
Joymona.
Then he wrote one M over it.
That's why, my lord, what my submission was that, my lord, when verification, he went, actually, he got the name as Joymona. Because it is that with the, my lord, LVO, the ERO has doubted. So verification was to be done by the LVO. So when he went to the house of the my lord, projected person Joymona, he found actually says Moimona, not Joymona. That's why probably he has later on changed the name while asking her.
But reference was never for Moimona. Petitioner is Moimona.
So that,
Huh?
my lord, is spelling mistake committed by the, my lord,
year or two
LV,
FT member.
Probably it is
no,
the
but which one you have to go by?
vote in a
What the
minor of
court
minor.
goes by, ERO's report?
Year of-
ERO's report.
Yes,
If the ERO's report, if you go by ERO's report,
it is.
let me see, and SP's report, SP also applies his mind, is it not?
No, no,
SP applies or not?
no,
Doesn't apply.
that is not.
He is a post office.
Yes, it is supposed to be
Okay. So ERO says Joymona.
Joymana.
Then why Moimana should be bothered with it?
My lord,
Huh?
that's why, my lord, it is Joymana in fact. Joymana.
No, this petitioner is Moimana.
Petitioner is Maimuna.
She is claiming, but she is
Huh?
Moimana. She is claiming she is Moimana.
No,
How? How do you see? You can put. Your very beginning initiation is Joymana.
Yes, ma'am.
And SP does not apply mine. It is ultimately the opinion is of the ERO then.
Yes.
Right. ERO says in his report, Office of the Electoral Registration Officer, 12/1998, Joymona, specifically.
yes.
And he made the inquiry done in the name of Joymona.
But yes,
Joymona. And LVO says whatever. Ultimately, it is his opinion. And he sent the reference in the name of Joymona.
Joymana.
Now, petitioner is Moimana. Then why should she bothered with this opinion? Joymona Khatun, alias wife of Mohan Ali.
only
That
my
is a
lord,
question I am putting, I don't
yes,
know.
I understood, my lord.
Huh?
Only the name is, in the name, my lord. The.
But very initiation, Joymona,
Yes,
ERO, you
very-
said
very essential, my lord.
SP does not apply mine.
SP does.
LVO's report does not have any bearing.
LBO's report has the bearing, my lord, to satisfy that, yes.
Yes,
this
but
person is-
he overrides, ERO overrides the LVO's report by sending the reference in the name of Joymona. And
Joymana.
proceeding initiated in the FT in the name of Joymona. And if somebody is has been issued notice, and Moimana will sit comfortably.
Definitely, well, she will sit together
Uh,
comfortably.
uh,
She will not come forward. That's true.
yes.
But my lord.
How to? What is the stand consistent?
My lord.
Then why you have come?
Now, my lord, the said judgment is sought
Hmm?
to be implemented upon me, my lord.
Then without verifying that there shall not be any coercive action, Joymona and Moimana is true,
Yes.
same. Yes, that can be done
Yes.
It can be done, no issue.
without verification of on the basis of documents. Till the next date,
Yes.
hard.
Yes, yes, my lord.
That is reasonable.
Yes,
Right. Without not to disturb Moimana.
Yes.
Not to apprehend Moimana without ensuring that on the basis of documents.
Yes.
Then Moimana and Joymana are same.
Yes. my
On the basis of documents,
lord.
yes.
otherwise they will get upper hand. Heard Mr. S. Islam Learned Counsel for the petitioner. Who is CGC number 1? Mr. Who is for Election Commission? Mr. M. Islam Learned Counsel, representing Mr. A.I. Ali, Learned Counsel for the respondent, Learned Standing Counsel, ECI for the respondent number 2, J. Pang, Learned Standing Counsel, Home and Political Department, and State Coordinator NRC for the respondent number 3 and 4.
3, 4, and 6.
3, 4, and 6. And Mr. D. P. Sharma, Learned Junior Government Advocate, Additional Senior Government Advocate, Assam for the respondent number 5. Full stop. case records of case number case 29 আছে BPT stroke 11th stroke FT 2383 stroke 2017 arising out of I am within bracket D bracket close T case number 8475 stroke 1998 have been are received in reference to the order dated 24/3/2025. Full stop. But on perusal of the case records, comma, it is noticed that the electoral registration officer in his report dated 12/1/1998 had reported that he had doubt about the citizenship of one Joymona Khatun, wife of Mohor Ali, comma, village Hugu Bari. Full stop. On the other hand, comma, the report of the LBO pertain to one in a line. On the basis of the said report of the ERO, the Superintendent of Police B within bracket Borpeta forwarded the case record to the learned chairman, comma, I am within bracket TT code at first, and thereafter matter was proceeded before the learned foreigners tribunal. Assam Borpeta 11th. First up. As per the case records, comma, the notice was sent to the 221 Joymona Khatun, wife of Mohan Ali, and as per the report of the process server, comma, the notice was hanged in a village club as no place of residence of Joymona Khatun at village Khugubari could be identified by him. First of the matter was thereafter proceeded with by the learned foreigners tribunal Borpeta. First 11th. So this is a report. Then what happens? Joymona, unless then if it is suppose it is remanded back, why should this be remanded back? Page 29, the page 29. He held it everything on Joymona. Notice not served. So Joymona is illegal migrant. How can this be set aside at the instance of Moymona?
If she is not murdered, then it can.
How can it be? Because your report also, something else, ERO's report, SP forwarding, all are in the name of Joymona. So what Moymona should be concerned with? until there is a reference and this opinion from the very initiation, ERO, SP, it is Joymona.
Yes.
And opinion is rendered on Joymona. Notice was sent to Joymona. Everything was held in Joymona. Then how this opinion can be set aside at the instance of Moimona? This is also a question. Is it answered?
No.
No, you are a seasoned FT lawyer.
No, my lord, the thing is that, my lord, we are not here to decide, my lord. First of all. we
Okay,
can
matter
decide that,
would require consideration. As the instant writ petition is preferred by Moimona Khatun alias Moimona Khatun, Nambu Sailevo for this purpose. Wife of Mohan Ali. It is provided that till next date of listing, the authorities shall not apprehend the petitioner without shall not apprehend the petitioner
Yes.
in connection with FT case number so and so.
Yes. sir.
She may be
some
wanted in some other criminal case also.
Yes, yes, yes.
So FT case number so and so. List the case on when do you want the regular way? After we okay. We do. Maybe 28th April. August. Find out whether Moimona can set the opinion aside
My lord, what
by
happens-
filing a writ petition.
Yes, my lord, what happens, my lord, in all these cases, my lord, is minor discrepancies are solved.
I could
Now,
understand,
yes.
but we cannot equate.
Yes.
We
Now-
cannot equate Joymona with Moimona
Now, my lord, she is coming that she.
unless you move a petition.
She is coming that she is not Mela Joymona, she is Moimona. We cannot decide here, my lord, whether she is Joymona. or not.
Absolutely not.
This has to be decided in the tribunal itself. That's why it's good to be.
Right, but question is the notice is Joymona.
That's why, my lord, if he can satisfy the tribunal by bringing all this.
No, there is no difference.
No, my lord, now, because if notice is, my lord, she appears before the tribunal. And if she can satisfy the tribunal that I am not this person.
The basic question is why should she
Yes.
approach? Because she is approaching this court because she has been apprehending that on the basis of that FT opinion, she
Yes.
could be apprehended.
Yes.
That is the only basis.
Because, my lord, another aspect, because all other, my lord, in fact, it's a simple, my lord, J and M. All others are same, my lord. The father name is same, the husband name is same, village is same.
So who will equate? And how? No, for sending it back. My basic
Yes.
query is common sense, not FT law. That at the instance of Moimona, because she is not saying I am Joymona.
Yes.
At the instance of Joymona, how this FT opinion can be
It cannot
set
be
aside.
appointed against him also, and she cannot come for set aside also. my lord.
Because all her documents is Moimona. Right. If you can trace out some document with Joymona, then yes, you can link. But otherwise, how an opinion of a tribunal can be set aside at the instance of Moimona, when the opinion is rendered in the name of Joymona?
Definitely.
Maybe it is a clerical mistake,
Yes,
but that
she
is
cannot-
assumes
cannot set
importance.
aside.
She cannot set it aside.
Yes.
And there is no reference.
Yes.
Yes. That's
So
true.
unless you move an application, perhaps, this opinion cannot be set aside at the instance of the petitioner.
Definitely.
Basic fundamental principle of law.
That is.
She is not saying, I am Joymona.
She's
Are you
coming-
saying?
Yes, no, my lord.
Huh?
No,
Yes.
No, my lord. No, my lord.
Yes.
No, my lord.
It opinion can be set aside. You answer that query that whether it can be set
Yes, yes,
aside.
yes.
If it cannot be set aside, writ petition is dismissed.
But, yes,
Writ petition will be dismissed. And order will that there shall not be any apprehension
Yes.
of the petitioner without they having any opinion of the FT. Matter is there, unless you move something
Yes,
from the state side. Solution is otherwise simple.
yes, I know.
Item 2. Yes, Mr. Islam, what to do with item 2?
Here, my lord, the petitioner, my lord.
And
is an old lady, my lord.
and this last record, like this case is to be dealing from WBC number 512/2025. Huh? Agora likhibo. Freshly typed copy of cause title. Cause title.
Earlier, it was, my lord,
Freshly typed copy of cause
Commissioner, my
title.
lord.
Okay, done.
Yes,
You submit it.
yes, my lord.
Then now
Earlier,
who
it
is
was,
she?
it was inadvertently written as.
Who is she?
Yes,
Tara Bhanu.
yes, my lord.
Yes.
She's an old
Opinion.
lady, my lord.
Opinion
Opinion is at case, my lord, 50, my lord.
50.
50, my lord.
Contested.
Contested, my lord. She
And
filed a written statement, my lord.
date.
She filed a written.
There is no dispute about name.
No, my lord.
Hmm.
But because, my lord, due to her old age.
What
my
is the
lord,
date of the opinion?
Date, my lord, 5/4/2021, my lord.
21. What is the common convention? Call for the records.
Yes,
If not arrested, not deported,
yes.
not to be deported.
Not to be
Okay.
arrested, my lord. Yes.
Not to be arrested, not to be deported.
Not to be deported.
Not to be deported and not to be arrested, my lord.
Huh?
Not to be arrested, my lord.
No, bail. That is bail.
Yes, that
That
is
amounts
bail.
to bail.
She
I
will
think
appear before the SP, my lord.
my sister says consistent practice is that if it is more than 1 year
Yes.
after FT
She is
records,
not aged
after
about 80
FT
years.
records,
My lord, the present petition, my lord, she is aged about 80 years, my lord. At this stage, if she is arrested, my lord.
He will not be deported.
since 21 you were there.
Yes.
So hard Mr. S. Islam.
She may be protected, my lord.
That is, protection is there,
Yes.
not to be deported.
But in the detention camp, my lord, she will die, my lord, actually, my lord. She is aged about 80 years, my lord.
Yes, Mr. Pang, where from 80 is there? Who is that 80?
In her own name has been recorded in the voter list of 1966, my lord.
That is doubted. That is doubted, otherwise.
And her name is also appeared in the NRC 1951 also, my lord, which is at page, my lord.
No, those are doubted. Now, show me anything other document, 81, 80.
Voter list, my lord,
Yes, Mr. Pang, 80, if it is 80 years.
80 years, my lord.
Otherwise.
Affidavit is shown as 80 years.
Yes.
That is true, madam.
Uh,
Otherwise, the opinion is of 5/4/2021.
Yes.
For last 3 years, she has not been absconded, arrested, or she has come before reasonable.
we put it 80 years, grand
Yes,
bail, hard. Mr. S. Islam. Learned counsel for the petitioner. Anybody whose names should be recorded.
Arcadis,
Oh, R.K. Devchuri, Learned Deputy Solicitor General of India for the respond number 1. Who is for election? Mr. M. Islam, Learned Counsel, representing Mr. A.I. Ali, Learned Standing Counsel, Election Commissioner of India for the respond number 2. Mr. J. Pang, Learned Standing Counsel, Home and Political Department and State Coordinator NRC for the respond number 3, 4, and 6. And Mr. P. Sharma, Learned Additional Senior Government Advocate, Assam for the respond number 5. This petition under Article 226 of the Constitution of India, Constitution, is preferred against an order stroke opinion dated. What is the date?
5/4/2021, my lord, which is page 50, my lord.
Yes, 50. Okay, 5/4/2021. Passed by the learned member, Foreigners Tribunal, Borpeta, 11th District, Borpeta, in case number page 50 child arising out of I am within bracket DT case number 5424 within bracket A dated /3/8. Full stop. By the said order opinion. The learned member of Foreign Tribunal had held that the petitioner had declared had held that the petitioner as a proceeding failed to discharge the burden of proving that she is not a foreigner within the meaning of the Foreigners Act, as mandated under Section 9 of the Foreigners Act. Meaning thereby, the petitioner had entered into India from the specified territory after 25/3/1971. Full stop. But I heard the issue notice, issue notice returnable on so and so. As so and so has appeared, accepted notice on so and so. Issuance of formal notice stands in which extra copies within 2 working days from today. Heard. Full stop. The learned counsel for the parties on the interim period. Full stop. The prayer for bail is opposed by the learned counsel for the official respondents. Full stop. Para. The petitioner has projected that at present, the petitioner is 80 years old. Full stop. Having considered the age of the petitioner, court is inclined to accept the prayer for bail, 5,000, so and so, so and so. SP,
Borpeta.
Borpeta, within 10 days.
5.
Obliged.
10 days.
Item 3.
बाकी ने 5,000 लिखी दियो, so iris status लिखी दियो, SP border लिखी दियो. Substitute to the official correct designation by submitting a
Please,
Presley
Your
type
Lordship.
so and so. Presley type so and so.
Item
For
3
number
and 4
5.
is for me, Your Lordship. Both the
Yes.
items, item 3 and 4
Yes.
is for me, Your Lordship. Both the items can be clubbed together because they are nephew and uncle.
No, tell me first one by one.
Yes.
It is of which year? Opinion is of which year?
Your Lordship, I have 2 opinions in my case.
Hmm.
The first opinion is 2014, White Annexure 13, page number 51 to 56. I would request your lordships to kindly go to page 53. The last paragraph. It is the type copy of the first opinion.
SP difference.
May I read, your lordship? As the name of the OP's father Hamid Khan is enlisted in the voter list of 1966, therefore OP's father Hamid Khan is a citizen of India as per section 6A1(2). It is wrongly typed as 11, your lordship. I seek apology for that. Of the Citizenship Amendment Act 1985. And therefore, considering the above, the OP MD Nayan Khan is not a foreigner.
Hmm.
Thereafter, your lordship, one of the youngest nephew of Nayan Khan, namely PR Ali, was declared foreigner. He approached before this Honorable High Court. Thereafter, the references or the opinions of the other family members, there are total 7 number of family members, were tagged and annexed before the Honorable Court to consider that he is also one of the member and wrongly been declared as not as a foreigner, whereas others are declared Indian. Thereafter, this Honorable High Court was pleased to take suo motu writ petitions for all the other opinions. And therein, kindly see Annexure 14, Your Lordship, page 57. Operative portion is page 63.
Where is their name of Noyan Khan? Okay, first name.
Yes, Your Lordship.
Somoto.
Suo motu. Suo motu 11/2017. Page 57, Your Lordship.
Why this has to be taken? Because of that. What is
Because-
the name of that person?
That person's name is P.R. Ali.
PR Ali. Okay. Then Nalbari, FT Nalbari,
F. Nalbari, Ghograpar.
Pograpar. Okay.
The case number for P.R. Ali is mentioned in page number 63, paragraph number 3.
Page number 3.
Page number 63, paragraph number 3.
For us, filed against foreigner tribunal.
So,
FT
227 of 2015.
case.
So for this case,
PR Ali to be a foreigner. Yes.
yes,
Then what is the reason? Requisition the case record passed in interim order should not be deported.
and
In the
kindly go to page 67, paragraph 14.
namely Noyan Khan. Council will submitted that Noyan Khan so had declared them to be not foreigner by citizens of India. And Ajibat Khan, similar passed order, therefore it was granted. In a case of petition being contradictory to so and so on perusal of the so and so. There was appreciation, no appreciation, I didn't whatever. Noyan Khan, that is, your earlier case number was 1125.
112.
Okay, the cases are so and so.
I beg your pardon, 1244/2006.
No, your earlier case number was 1125.
For Nayan Khan.
No,
Your Lordship.
page 51, you say.
Yes, Your Lordship. It is.
1125 only.
Yes, Your Lordship.
So that was included in the purview of suo motu
Yes, Your Lordship.
petition,
Yes, Your Lordship.
writ petition.
There were others as well, like, for example, Ajibat Khan, who had died.
So your is one. Prosecutor will set aside the following order. Set aside the Noyan Khan is set aside. Noyan Khan come to 66. Para 13. Small Roman 2. 1125 is set aside.
Set aside.
So it is not,
Done.
stated not.
Yes.
Nothing remains.
Yes, Your Lordship.
If this order is not challenged. So you attain finality. So we are from ground zero.
Yes, Your Lordship.
We are from ground zero.
Yes, Your Lordship. I admit to that fact. And therein after, when this.
Thereafter is 2018.
Yes, Your Lordship.
This is the opinion.
Page
Page
number 69.
69. Then here in view of so and so of the Noyan Khan is a foreigner post 1971 scheme. Right. Then this is of 2018 opinion.
Yes, Your Lordship.
We can issue notice and call for the records
Your Lordship.
and
record may
not to
called
be
for.
deported 2018.
May I please, Your Lordship? My humble prayer, records may be called for, which is very necessary to go further with the case. But
How old are you?
I am 28 years old.
Absolutely then. Heard Mr.
As sure.
As sure. Learned Counsel for the petition. R.K. Dev Chudri, Learned Deputy Solicitor General of India. For the response number 1, Mr. J. Pang, Learned Standing Counsel, Home and Political Department and State Coordinator, NRC. For the response number 2, 3, 4,
And 8 men.
8.
Yes, Your Lordship.
Mr. Miss P. Borua, Standing Counsel. Election Commission of India, for the respondent number 6. Who represents 7? Mr. P. Sharma, Additional Senior Government Advocate, Assam, for the respondent number 5 and 7. Okay. This petition under Article 226 of the Constitution of India is directed against an order stroke opinion dated 19/4/2018, passed by the learned member Foreigners Tribunal, 4th Nalbari, within bracket Khograpar, in FT case number space 69, null so and so, arising out of SPB reference number 1948/2024, posted by the order, said order, impugn order, stroke opinion. The learned tribunal has held the petitioner proceeding as a foreigner of post 1971 stream. Learned counsel for the petitioner submitted that the learned tribunal, without proper appreciation of the documents presented, documentary evidence presented before the by the petitioner proceeding, had proceeded to hold the petitioner to be a foreigner. Full stop. Para. Issue notice returnable in 4 weeks as so and so appeared so and so. Extra copies. Para. Had the learned counsel for the petitioner on interim prayer. Full stop. The prayer for interim relief. Call for the records. Call for the records of so and so. The prayer for bail will be considered after receipt of the records from the records of so and so case number. In the meantime, it is observed. In the meantime, observe that the petitioner, if arrested, in the meantime, shall not be deported.
Item 4,
What is same but?
Sir, you missed the bus. I passed the order. Why did you say 25 years? My sister pointed out. You missed the bus now. Why did you say 25 years?
I'm 28, Your Lordship.
You still miss the bus. Yes, mister. You still miss the bus again. No third chance. Yes, madam. Yes, sir. Where is the opinion? Same thing.
Same thing.
Same person.
Same.
Different.
This is his nephew, Your Lordship.
Nephew. Then obviously he'll be less than 25 years.
49.
He's more.
Same. FT case number is 73. So both the uncle and nephew shall stay together. Same thing. Same order.
Your Lordship. at least
Twice.
Just to stay the
You
proceeding.
increase
The
the
police is
age by
harassing
3
them.
years next time. From 25 to 28.
That is my misfortune, Your Lordship.
Yes. What to do?
Much
Yes,
obliged.
next.
item 5,
Samartha Bhanu.
my lord.
A. Paul challenged as senior has made a party as per in a present posting. The Jagan is not a necessary party. So when so raise this recording, correct the cost handle. Call for the records. Yes. Yes.
My lord, the petitioner agreed with the
Uh,
open order
opinion is
annexus 7, page 38, my lord,
Annexure 7,
39 onwards.
39 only. Mm.
A party portion,
Somotovano, wife of Asabal.
a party portion of the open order is page 42, my lord,
What is the date of the opinion?
6 March 23.
2020. Yes, sir.
There is nothing in this matter.
Hmm?
Somebody, please.
What about prayer for bail?
Put it, my lord, we have board merit. Whether
Huh?
we have to see on merit. My lord.
Huh.
If your lordship see finds that there is a case, then your lordship may grant bail in the case. That is the procedure, my lord, after calling for the record. If the record
Is it?
yes, my lord. After present of the record, if your
Hmm.
lordship satisfied, my lord, that yes.
I don't know the convention or procedure
Yes.
followed.
That is the procedure.
Huh?
my lord. If your lordship, my lord, satisfy on the basis of record, then
Hmm.
your lordship will grant bail.
Yes, let that then it come before the regularments.
That is fine.
Heard Mr. Paul. There has to be consistency, right?
Yes. Okay.
Architecture. One. We'll just post the matter.
Yes.
Ms. So-and-so Borua, standing counsel, PCI for respond number 2. J. Pine, land compassion. 3, 4, 6. P. Sharma, 4, 5. The case records of so-and-so case number, comma, as called for have been received as sought for by the learned counsel for the parties, placed the case on when 23 April, immediately after vacation.
23.
23.
Item 6.
Sajid. Yes.
May it please, Lord, I refer to order dated 12/3/2025.
Yes, Mr. Sheikh, you wait for regular events on 23rd. Records received.
Record
Same
not
order. MS Sheikh.
received. Lord,
I do not want to
my
break the
humble
consistency.
My humble submission before your lordship. She is a lady, my lord, as it about 63 years. 63 years.
63 is not equal to 80.
As per voter list, my lord.
Ah.
As per, my lord, so my lord.
Let the regular events come and decide.
My lord, in that case, my lord, remainder may be sent by the registry because record was called for
Oh, record aha nahi.
12/3/2025.
Oh, record is not
Received,
available.
not received, not received, my lord.
Oh,
So in
then
that case, my lord,
receive send fresh reminder. Heard, Mr. MS Sheikh, Learned Counsel Board of Petitioner. 1, Architect Jury Silo. P. Borua, then Architect Jury 1, J. Pine, or Mr. Z. Sharma, Standing Counsel, Home and Political, and the State Coordinator NRC.
Yes.
For 2, 3, 6. P. Borua, Standing Counsel. Election Commission of India for the rest of 5, P. Sharma. The records of FT case number so-and-so by the order dated 12/3/2025, the record of FT case number so-and-so was called for from the office of the learned member for Forest Tribal Fort, Gwalpara, Assam, post of, as per office note dated 5/4/2025. comma, the record has not been received, close the registry to send fresh reminder. For requisitioning the record of so-and-so. So that the record is received on or before 22nd of April 23rd of April 2025. Release the case on 25/4/2025. The order is to be brought to the notice of the registered judicial. First, release the case on so-and-so in a motion column.
Item 7.
May I please?
Ah.
In this case, my lord, we have put to challenge Diet Service Rule 2010. And
Diet service rule.
yes, sir. So on the count that, my lord, this Diet Service Rule is not at per the NCT mandates. NCT prescribes, my lord,
Yes, who is the standing counsel? Education. Education. Yes. Notice. Why notice? If the repetition is not privacy maintainable.
Actually, our Mojumdar will be
Hmm?
Mojumdar will be appearing and he has some personal difficulties.
So that is why notice.
They
Huh?
are better after being because
Okay, we'll proceed. Let us proceed to the next stage. Then heard Mr. B. Purakasto, learned counsel for the petitioner, and Miss B. Deka, learned counsel, representing Mr. R. Mojumdar. He is standing counsel, learned standing counsel, Elementary Education Department. For both the for the respondent number 1. Mr. I alone, standing counsel. Standing counsel. National
NCT.
Council for Teacher Education, NCTE, for the respondent number 2. What do you say about this? Rule, which rule? What is that rule?
rules annex, last annex, my lord, annex,
Huh?
annex 13, page 90, my lord.
Page
90.
90. What is that part which is ultra virus?
Part is, my lord, it is not included the qualification for the.
Where is that?
That is not included, my lord. That is not given in this rule.
Huh?
That is not, rule 5, actually, page number 91.
So something is contrary?
Rule 5, page 91, it says, my lord, the post of principal is promotional. It should be filled.
Oh.
Post of principal should be promotional.
Promotion, yes.
Promotional.
Huh.
And, my lord, page 78, my lord, the lord should find.
78.
Yes, lordship. Before this, page 82, my lord, kindly go, 82, last paragraph. Page 82, last paragraph. NCT as a regulatory authority of Government of India under MHRD, making consistent effort to regulate and ensure coordinating growth of teaching education system in the country by giving time for proper rolling out of BA, B.Ed, BSc, B.Ed as integrated program for recognition of new TEIS by Gazette notification number such and such published on such and such, which stipulates that for the post of principal / HOD, PhD qualification is essential for the post of lecturer, either PhD
It
or.
does not indicate it is a direct recruitment.
Not that.
This part, where is that part?
For promotion, my lord.
Where is that promotion is
Page
offending to NCT regulation?
Page 78, my lord.
Page 78. Let us see. Yes.
5.2 qualification.
Yes, where is that? It is direct.
My lord, desirable MPhil PhD, my lord.
That is, PhD is different. Now you said that it is a promotional post.
The promotion for the
It
purpose.
should be a direct recruitment.
No, not
as
direct.
far as.
No,
So that there is no.
No.
Okay, then what is? Only
Our
PhD.
PhD should be included.
Yes, what is there in the qualification in the state rule?
The state rule is nothing prescribed, my lord.
Nothing prescribed.
That's why.
It can be filled up by executive instruction. Yes.
Executive instruction.
Is there any executive instruction?
No,
Huh?
no,
No.
no.
How it is consistent? then?
That
Inconsistent. How it is inconsistent?
Yes, they have issued the mallet notification in compliance of the NCT direction mallet.
Where is that?
Mallet, that is annexer 85, mallet page 85, annexer 11C. While issuing this notification, my lord, they have not included the post of principal. They have included other post, my lord.
Okay. That is not, cannot be ground to set aside this.
No, we are not setting aside, my lord.
Huh?
We are not for setting aside. We are for, my lord, incorporating the mandates of the NCT in the present rule, my lord.
So what
Only
please
the-
amend
only-
that PhD.
Only the PhD qualification is required.
How it is before a division bench?
Because it's a rule challenge, rule.
What is the challenge of rule? Rule is silent.
Rule is
Rule is silent.
Yes.
Rule is not ultra-virus to
In the-
NCT
Earlier-
rules.
There was earlier round of litigation, my lord, in the single bench, my lord. And that during that, my lord, the honorable single judge could not take up the issue of promotion, where the promotional exercise has been done without taking into consideration of the PhD degree for the post of
No,
principal.
that is, no,
that-
question is, the question is that adjudication should be before the division bench.
Yes,
If virus of the rule is challenged.
yes.
Now, virus of the rule is challenged because of absence of something in the rules.
Yes,
It is not contrary. Something which should have been there in the rules.
therefore it is in
For that this rule cannot be set aside.
the rule, it should be modified.
There should be addition, you
Addition,
say,
Modification,
right? Is it
modification, yes, my
a division bench matter?
yes.
How?
Earlier occasion also granted liberty to file this case.
I don't know, just because rule is annexed, something is questioned about the rule. So, before the division bench. What is the prayer here? Something is missing. That does not make the rule, perhaps to my little knowledge,
Earlier
other
occasion,
virus.
earlier,
Something, Constitution bench says, if something is missing in the rule, that can be filled up by way of executive instruction also.
yes, that can be done.
In the absence of any amendment.
Yes.
It can be made by amendment, or it can be filled up. The gap can be filled up by executive instruction.
Notification.
Right. Government has that power. So for that, the rule cannot be made.
Rule, because earlier round of litigation, my lord, this issue was raised.
No.
This issue was raised, and this honorable
Something
court,
is,
the honorable single judge, my lord, and it was up to in the writ appeal also, my lord, there's writ appeal, and the writ appeal also, my lord, this observation has been.
amending, you satisfy on the next date before the regular bench. No, I am not sure. This is the matter of division bench. Amending, court cannot direct also amendment. Right.
Court cannot direct, but the in case.
It is desirable that kind of expression of opinion can be given, but cannot direct amendment. And
And,
if the NCT rule mandates that PhD is a regular thing, that can be observed.
Yes.
That can be observed. For that, I don't think it is a division bench matter. It is up to you to satisfy.
My lord,
I am sitting it for a moment. You will satisfy on this point to the regular bench. Heard Mr. B. Prakash of Sohol too. Likhok. The prayer in this petition is for setting aside and quashing and stroke or modifying and or stroke amending the Assam District Institute of Education and Training within bracket Diet Service Rules, 2010 by incorporating PhD degree as an essential qualification for the post of principal, Diet as per the mandates of the NCTE within bracket recognition norms and procedure bracket close regulations, 2024. 14, first of prima facie. the rule that is Assam District Institute of Education and Training Diet Service Rules, 2010. Privacy SL is made to the so and so on the ground that for the post of principal diet, the rule has not incorporated the qualification of PhD as an essential qualification to be. I think you have challenged promotion also. No, to be promoted to the post of principal, diet, post of, in a sense, the petitioner has made contention as regards omission to incorporate the PhD qualification as an essential qualification for the post of principal, which, according to the petitioner, is contrary to the NCT within bracket recognition, norms and procedure regulations, 2024. First of all, the learned counsel for the petitioner has to satisfy, has to make submission as regards maintainability of the writ petition, consideration of the writ petition by the division bench. You also, whether it is the case, because you will also lose a forum in the meantime. Lays the case on review. Bihur Pisot, immediately Bihur Pisot, review. 28 April, Monday. We'll come back sometime.
Item number 11.
Yes.
Here in this case, my lord, petitioner has declared foreigners, my lord, also will find the judgment at page 75.
Yes, Mr. Sharma,
Yes, no, notice may go, madam, contest of case.
on bail,
Proceed new opinion wrote, 2025 opinion wrote.
bail granted. Heard Mr. A.R. Sigdar, learned counsel for the petitioner. Arkidev Choudhury, learned Deputy Solicitor General of India. Silo, for the response number 1, G. Sharma, learned standing counsel, Home and Political Department, for the State Coordinator NRC, for the response number 2, 4 and 6. Mr. P. Sharma, as Additional Senior Government Advocate Assam, for the response number 3, and Mr. M. Islam, learned counsel, representing Mr. A. Ali, learned standing counsel, Election Commission of India, for the response number 5. This petition under Article 226 of the Constitution of India is preferred against an order stroke opinion dated 29/1/2025, passed by the learned member, Foreigners Tribunal, Fort Gwalpara, Assam, in FT case number so-and-so page 675, arising out of reference FT case number 146/2011. First of, by the said order stroke opinion, the learned Foreigners Tribunal has held the petitioner reciprocity to be a foreigner who had entered into India illegally from the specified territory after 25/3/1971. First of, Mr. Sigdar, learned counsel for the petitioner, has submitted, petitioner reciprocity has submitted that despite submission of sufficient document evidence to establish the to rebut the claim of the reference that the petitioner proceeding is an Indian national, the learned tribunal, Foreigners Tribunal, has are in properly appreciating the evidence. Post of issue notice returnable in 4 weeks as so and so has appeared, accepted notice so and so so and so. Issuance of formal notice and dispense with extra copy in 2 working days. The learned counsel for the parties are also heard on the interim prayer for bail. Full stop. The prayer for bail is opposed by the learned standing counsel, Home and Political Department, so and so. Full stop. Having found that, having regard to the fact that the proceedings before the learned foreign tribunal is a contested one, and sufficient documents, the number of documentary evidence have been presented before the tribunal. But this court is of the opinion that this court is inclined to inclined to consider the prayer, inclined to grant bail. So and so, 5,000 iris fingerprint, 10 days, SP border, Gwalpara. LCR call for, huh?
My lord, time, my lord, for appearance, my lord, time. for-
10 days.
Deeply obliged.
For admission, item number 12.
May it please your lordship.
Hmm.
My lord, in this matter, the present writ petition has been filed challenging the impugned judgment passed by the learned foreigners tribunal, my lord.
LCR received.
LCR has
D Das,
Rathi, my lord.
D Rakhi,
Rathi.
Rakhi,
RATHI.
RATHA,
THI.
I. Petitioner, learned counsel for the petitioner, RK Deputy, learned Z Sharma, learned standing counsel, Home and Political Department, and State Coordinator NRC for that. Spot number 2, 3, 5, 6. P. Sharma, Addition Senior Grammar Advocate Assam for that. Spot number 4. And Mr. M. Islam, learned counsel representing Mr. A. Ali, learned standing counsel, ECA for that. Spot number 7. Post up. The records of case number have been received. Learned counsel board of parties have submitted that the matter can be heard on merits. Post up. The matter is admitted for hearing. The earlier interim order, the interim order passed earlier, shall continue until further order.
Much obliged. Lordship, if any date may be fixed,
In usual course,
deeply obliged.
you are enjoying interim order until further order.
Much obliged.
Item 13.
And there is no representation on behalf of the petitioner today on call. The counsel for the state respondents are present. In view of non-representation on behalf of the petitioner today on call, let the case come up for inch of justice be listed again after 3 weeks.
Item number 14.
May I please, your lordship?
Yes, sir.
Lordship, it's an ex parte opinion, lordship. And the petitioner is already taken in custody, lordship, and he is in custody since December, lordship. And so prayer
Okay, we
for-
put it on 22nd then.
Yes, lordship.
All right, Mr.
M. Ahmed.
M. Ahmed, counsel for the petitioner. R.K. Deputy, and Deputy Solicitor General of India for the response number 1. Z. Sharma, 2, 4, 6. M. P. Sharma, 5. P. Borua, 4. লিখি দিব হ্যাঁ, by standing counsel so and so so. এখানে লিখি দিব হ্যাঁ, বুঝছে? লিখি দিব standing counsel so and so so and so. 4. বেলেগ order পাছ আহিব। Okay, as sought for by the learned counsel board of parties, list the matter again. Is the matter on 23rd April?
Yes.
23rd April.
Item 15.
আগৰটো নিচা লিখি দিব নহ'লে আগৰটো নিচা লিখি দিব there is no representation fine so after 3 weeks
Item 16.
same interim order is there side over no try to do heading there is the case one after 25 4 bail for bail it is there where so 25 4
Number 17.
okay same khali likhi dibo 28 4 28 4 right 28 4
Item 18.
no representation likhi dibo yes sir
My lord, impugned order page number 28, my lord. LCR was called for, LCR is on record, my lord. There's no interim, my lord, I'm praying for interim, my lord.
$2024 anything November 2024
Last occasion might not what happened in this case. The lordship may kindly see why it was not granted.
why it was not granted
At page 23, my lord, your lordship. Okay. Page 23, para 4. They got married on 5/3/1996. That is this categorical statement in WS matter as well as in evidence matter.
got married
Yes.
Rahela Bibi yes
5/3/1996. Then my lord, again in evidence, page 54, my lord.
54
Yes. Para 4. It is a categorical statement. I got married on 5/3/1996. Then in Frost, my lord, Frost page 61. This was done in 2023, my lord, cross examination part. Page 61, my lord, fourth para, in fact. I got married with MB Ali about 28 years ago. It was in the statement in the year 2023. That means it is probably 1995. If it is 28 is accepted. 95, 96. Now he is relying on a document that is the Kabil Nama, page 55. The date of marriage,
page 55
50.
50
The 8th column. Here, Tariq Nikko Lagivo, here in the left hand column, left hand side, 5/3/1986. So he is relying on this document that on the basis of this, my lord, that she is the daughter of one.
so contradictory
Yes. And the entire my lord, evidence here said she got married in 1996. Last occasion, my lord, humble question was there that he has to clear my lord, come with clean hand. Is when did she got married? She herself is not clear. But how can we accept on the basis of this document? Is 50 that she is the daughter of this my lord.
Ganesh.
Ganesh Ali. Ganesh sir. So it has to be heard in full ballot. Then only the interim or whatever.
okay we'll put it on 22nd then let the regular
May
bench come.
I say this, my lord? I am not relying on only this document, my lord. My lord, page number 39, my lord. there is this next of kin certificate also, my lord.
No, we are not doubting anything. We are not expressing any view.
My lord.
Let it be on before a regular bench then,
My lord.
because consistent stand.
But I am only praying for entry, my lord. Till that time I am be protected, my lord, because the police is disturbing me. And this page number 39, next of kin, my lord will see in the LCR, which is page number 97. in the LCR.
That is a documentary evidence. You presented before this tribunal, page
Yes,
50.
Yes, yes. Page
And
number
this
39.
is completely contradictory to what your evidence is before the tribunal.
My lord, there is a
How do you justify it?
my lord, there is a minor contradiction. There is
No, this is not minor contradiction. 10 years is not minor contradiction.
my lord, but I am
You are the only person who knew
my lord,
when your marriage was solemnized.
my lord.
Other cannot vouch for it. And if document normally does not lie, man lies. That is a consistent version of the code also. Document does not lie. Man may lie. Person may lie. But document page 50 is clearly contradictory to your evidence before the tribunal. So how can this be? I am not expressing anything. It will be before the court, regular court, because consistent view among petitioner, who is the standing counsel, central government counsel.
Deputy Solicitor.
Okay. The RK Deputy. P. Borua, Election Commission of India 2. J. Payeng, Home and Political Department and State Coordinator NRC for the response number 3, 5 and 6, and Mr. P. Sharma 4. The records of so-and-so have been received. Learned Counsel for the parties have made submissions on it. Also placed the case again on the 22nd of April for further consideration. 23rd. The prayer for bail will be considered on the
My lord.
next date.
Grateful, my lord. For hearing, item number 20.
Yes, Mr. Talda.
My lord, should it be in the regular bench?
I Taludar. Petitioner. Market Deputy 1. P. Borua. PCI 2. J. Payeng. Oh, sorry, no, J. Payeng. Home and Political Department, State Coordinator NRC 3, 4, 5, 6, 7. Okay. Matter be admitted? Oh, it is already admitted. Software by the learned counsel for the parties lays the case for hearing on.
It is up to your lordship.
Okay, after 3 weeks. You are enjoying interim order?
Yes.
Okay.
Nothing in this case is surviving.
Okay.
My lord, I ask my lord's pardon, my lord. In item number 17, my senior is in legs, my lord.
Item number
Item number 17, my lord.
17.
17.
Okay, on the prayer of Miss
A Devi, my lord.
A. Devi, learned counsel for the petitioner, lays the case on when do you want? After Bihu?
After Bihu vacation.
When? 20? Already fixed 28/4.
Oh, yeah, obliged, my lord.
Okay, Pakistan.
Item 21.
This is also 21. 21.
Lordship, I'm for the appellant.
This
is a matter where-
My learned can start. The lordship may not be
Oh.
to take up this matter.
Looks familiar. Looks familiar.
Lordship, that order based upon
But
that order.
that order.
Whatever the person
that
have
order
appeared
has been
somewhere,
record.
somewhere.
That order only directed us to actually place our representation.
Anyway, it will be
before-
before next bench. This is the case before any other bench without one of us. Because looks familiar.
But my lord had not gone into the merits at all in that matter. That order.
Whatever, but
Based upon that order, the impugned order was. issued.
okay.
May I request for a specific date then?
No, if I'm not, I'm not there, I will not enter into a, this will
There's
not
some
be proper.
urgency- This is an
Ah.
urgency.
The learned counsel, as the learned counsel for the petitioner,
Appellant.
appellant has expressed urgency, comma, the registry to release the case in an expeditious manner.
Obliged.
I'm sorry, my lord, I taken number 15, my lord.
Okay, on the prayer of Mr. So-and-so. Mr. Your name, please. Learned counsel for the petitioner, release the case on so-and-so. Court master will give it.